Hello, everyone. Hope you enjoyed your lunch. Welcome to this session called the AI Act, Where Are We and Where Are We Going? And I'll just note that it's part of a grouping of several sessions on AI and specifically the AI Act, so there's a lot of discussion at the conference about that. Just a quick roadmap. I'll introduce the topic and the session. I'll introduce the speakers. We will then have a short pre-recorded presentation by Commissioner Didier Reynders, the Justice Commissioner of the EU. And we'll dive into a Q&A session. And I urge you all to raise your hand and to ask your questions because we'd really like it to be as interactive as possible. So the Artificial Intelligence Act, the AI Act, was proposed as a regulation by the European Commission just about a year ago on April 21st, 2021. It provides a legal framework for trustworthy AI, that's the goal, and it follows on a white paper on AI from February 2020 and ethical guidelines for trustworthy AI, which were proposed by the high-level expert group assembled by the European Commission in April 2019. At a very high level, the AI Act is a product safety and liability regime. It sets forth principles for AI systems, such as human agency and oversight, technology safety, privacy and non-discrimination, fairness and accountability. It is a risk-based framework, much like GDPR in this respect, categorizing different systems under different risk scores, if you will, starting with prohibited systems, such as ones that provide social scoring or real-time remote biometric identification. Then there are high-risk systems, which are specified in an annex to the AI Act. And you can see that it's pretty broad. It includes things like systems in the context of education, scoring tests, for example, for students, employment, or the administration of justice, as well as various other activities from a long list. And then you have regular systems or non-high-risk systems which are subject to less scrutiny. The law provides, it's very technical and, dare I say, even technocratic in the structures that it creates. When I looked at it for the first time last year, I was actually surprised that the word individuals is hardly mentioned at all in the Act. It's, you know, like 100 pages long. The first time you see the word individuals is in Article 52. So after all of the recitals and deep into the regulation, and it's in the context of pretty narrow transparency obligations. The AI Act sets forth roles for like a whole plethora of organizations. Some of them are on the commercial side, like providers and users, meaning not individual users, but organizations that use AI systems, importers and distributors and third parties. And then you have organizations, entities that are mentioned on the regulatory side, like notifying authorities and conformity assessment bodies and national accreditation bodies and market surveillance authorities and national authorities and even an EAIB, a European AI board. Importantly, the law defines AI systems. It doesn't define AI, but it defines sort of the basic term, the cornerstone is AI systems, and maybe we'll talk a little about that definition. It addresses some hot-button issues in our space as privacy technologists or lawyers, such as facial recognition technologies, emotion recognition systems. It has a sanctions regime with even higher sanctions than GDPR. So GDPR, you know, the maximum is 20 million euros or 4% of annual turnover. The AI Act has 6% and 30 million euros, so maybe a bit of inflation there, which of course is very trendy. And it has a 2-year implementation period. After saying all this, it sounds like a very kind of top-down, heavily regulated framework. I will say that it also includes strong language about the European Commission aiming to prevent rules that stifle innovation. So one of the goals of the regulation is to actually facilitate activity in this space in Europe, and I think that's evident. There was a public comment period and hundreds of comments that were filed by the summer of last year. And I urge you to go back and look at them because some of them are very interesting and substantive from civil society organizations, from academics, and from industry groups, some regulators also. And of course, the AI Act is now in trialogue, and we'll hear more about where it stands. So with this introduction, I'd like to introduce our speakers for the session. And one of them, I believe, is should be on the screen at some point. So I hope you're there. Sylvia Gipman-Stepien. Is Sylvia there? Sylvia is head of cluster on EU economic policy and emerging technology at Google. Hi, Sylvia.
Hi, everyone. Thanks for having me.
Great. Well, we don't see Sylvia apparently yet, but there she is. Great. And next to me here is Gian-Claudio Malghieri. Gian-Claudio is Associate Professor of Law and Technology at EDHEC Business School in Lille in France, and is also the co-director of the Brussels Privacy Hub.
Thank you very much.
Next to Claudio is Anna Moshibroda, who is joining us from DG Justice in the European Commission. Hi, Anna. After Anna is Katarzyna Szymlewicz, who is co-founder and president of Panoptykon, a Polish NGO defending human rights in a surveillance society. She's also affiliated with European Digital Rights. She was the vice president of the organization, EDRI. Hi, Katarzyna.
Hello.
And last but not least, Charles Albert Helleput is AE partner and head of the EU Cyber Data and Privacy Practice at Steptoe. Hi, Charles.
Hi, everyone.
So with this introduction, we will now turn to a short speech, and I think it's really short. It's like between 5 and 10 minutes, from the EU Justice Commissioner Didier Reynders. S'il vous plaît.
Dear participants, it's a pleasure for me to take part in this conference, and I'm grateful that digital technology makes it possible. Digital technologies are transforming production, distribution, services, and business models as we speak. The pandemic has only accelerated this trend. Artificial intelligence, high-performance computing, and mobile solutions were instrumental in addressing the unprecedented challenges in the pandemic's context. The horrible events in Ukraine have further changed our view of digital technologies and cybersecurity. and trust is becoming increasingly important. The answers to the question raised by the new industrial revolution must be grounded in our values. This means respecting fundamental rights and safety. It means putting people first. That is the European Union's approach to the use of AI, which brings a lot of potential, but also risks. We need to address these risks to ensure that the use of AI does not undermine but fosters democracy and the rule of law and respect for fundamental rights. And if we can scrutinize how AI systems are used, we can also assess their efficiency. Our proposal for a regulation on a European approach for artificial intelligence, currently under interinstitutional negotiations, stands up for the fundamental rights and safety of AI users. It follows a risk-based approach. For example, we identified high risk in areas such as education, employment, access to credits or public assistance benefits, law enforcement, migration and asylum, as well as in justice systems and remote biometric systems like facial recognition applications. The European Union already has rules protecting fundamental rights, but certain black box AI applications are complex and opaque, which can be a challenge. The regulation will help to ensure that in future, high-risk AI system designs comply with fundamental rights, and the new requirements will ensure that national authorities and courts can investigate and address possible breaches of fundamental rights obligations. To achieve this, we are also proposing to oblige system providers to include appropriate documentation and testing of high-risk AI applications, as well as adequate human oversight and reliability and accuracy of the systems. The users of AI systems are the ones who need to respect fundamental rights, so they need adequate information from the providers to ensure suitable use of their applications. But I want to stress that the AI proposal is not an instrument for addressing all challenges related to the use of AI. Rather, it adds new quality and transparency requirements and helps to ensure that we can continue to rely on the instruments we already have. We are also assessing whether targeted changes to liability rules are necessary, and a proposal on this will come in the second half of the year. Victims should be able to claim compensation when an AI system causes harm to increase trust. I'm confident that trust in AI technology will boost uptake of AI in Europe. Like the GDPR, the EU's approach to AI is already making waves around the world. As the first initiative in the world to provide a legal framework for AI, the future EU AI Act will set the global standard for a more robust, ethical, and fair technology. I'm sure that you will have plenty to say about it in the next panel, and I wish you a successful exchange of ideas. Thank you very much.
Great. So we are grateful for the Commission for providing this introduction by Commissioner Reinders. And maybe start with the Commission. I'll ask you, Anne, where we stand in terms of the process, and is there a timeline for concluding the process with the AI?
Hello. Hello, everybody. Very happy to be here at this panel today. So as regards the timeline, so as you've mentioned before, the Commission presented the proposal over a year ago, which of course started the first reading of that proposal in both co-legislators, so in the Council and in the European Parliament. Maybe we start with European Parliament first. So the works are ongoing. We have two committees which took the lead on the file, which is Internal Market Committee and Civil Liberties Committee. Following discussions in those committees, there are the draft reports which have been proposed by the co-rapporteurs. The report of the URI committee, which is also involved, has been proposed and put forward in March. And the end of April, we had the proposal for the draft report from the URI and Internal Market, from the Internal Market and LIBE committee. So right now we are at the stage where the members of the parliament have time to propose the amendments to this report. And that, of course, will also trigger further discussions. And from what I know is that there is a scheduled plenary session and vote on the report in November this year. There's a quite intense reading of the proposal in the Council as well. There has been a very numerous meeting on the various council groups leading of the telecom, and which I think is a good sign because it also shows that the member states have put a lot of attention into this file and they clearly prioritize work on this file, which I think is a very good sign. There has been a number of proposals coming from the Slovenian presidency and the French presidency. The French presidency right now is putting forward the complete compromise proposal. And the work will continue with the next presidency. So the Czechia is taking over. But considering the rather advanced stage of the discussion in the Council, I think we could expect that there will be a general approach, so basically agreement within the Council on the amendments proposed by the end of the Czechia presidency. So I think I will stop here in the timeline. Thank you.
Great. Does anyone else on the panel want to comment just about the process, where we stand and your expectations for kind of the progress, or do you want to jump into content?
As a representative of European Digital Rights Network that does a lot of work currently in the European Parliament, I can only thank for the draft report that came from IBE and LIMCO, which is a good step towards what we are fighting for. I will cover main goals of that fight in the next round. But it's still far. The draft report is still far from the expectations, at least coming from civil society. And honestly, right now we have a very crucial time in the Parliament. So my only intention is to stress how important it is right now to talk to members of the Parliament and make an effort for everybody who wants to introduce that legal act, because now is the key phase. If we don't have something in the final report from IMCO-LIBE, it will be incredibly difficult to fix it in the plenary phase. So in a way, it's the next quarter or never.
Charles?
Yeah, maybe I'll just add a couple of words there. So one, and you mentioned it, Anna, so I think it's really important to realize that we have a lot of committees working on that piece of regulation, which to some extent is good, but also means that it will be very challenging because everyone will be keen to introduce a little step and little addition in the text at the Parliament level. And you can see that the Commission seems pretty anxious to have that act moving forward. I'm not sure whether you followed the hearing at the committee at Parliament level, but you had the Commission really saying in the end, we are really hopeful that we can have that act passed during this Commission work program. And as we all know, it's still a bit far away, but if you take all of the timeline for the EU institution to work properly, we couldn't wait like the next 10 months for trying to have a position and have that adopted. If we want this adopted, we probably need to make progress relatively quickly in a subject area that is pretty complicated.
So let's maybe, given that this is the window of opportunity to make things better, maybe we start with some thoughts about that. So criticism, problems that you see in the current text, and we have 4 hours to, I'm joking. So Katarzyna, maybe start with you. As you said, you represent the civil society view here. So what does civil society think are the shortcomings of the current language?
Thank you for giving me opportunity to cover this in the 3 minutes we have. And honestly, it's incredibly difficult challenge to give a fair account to what civil society has been contributing in the process. I have here just one of the very many statements published by European Digital Rights Working Group. That one that I have in hand has been supported by 123 civil society organizations, which only shows how important that legal act is and how many civil society groups are counting on it. And the list of flaws and gaps is long and complicated. I can only give you the headings. Please bear with me, and do go for more details to the statements we publish on EDRI website, or follow excellent experts from EDRI, including Daniel Lofer, Sarah Chandler, both here today in other panels, going far more in depth in these gaps. So back to the headings. The first heading we've been stressing from the very beginning is that we need to fix the risk-based approach that we have in the Act to make it functional, to make it future-proof, and to give European Commission and other bodies real chance to embrace developments in the market. The risk-based approach, even if we like that concept, we do not attack it in EDRI, cannot be that rigid as it has been proposed by the Commission. Many of you who have read the Act know that only one aspect has been made flexible, which is a list of specific AI systems deemed to be high risk in the Annex 3, but without even giving the Commission ability to add new area headings in the Annex 3, not even mentioning the lack of ability of adding more prohibited systems or stretching the list of manipulative systems called limited risk. All that needs to be improved, which boils down to a number of detailed amendments that have been filed by civil society. Some of them already made it to the draft report, so there is some progress on the flexibility, especially of the high-risk systems list that has been increased, the flexibility here, but until now, we haven't seen much progress on the prohibited systems. So with that regard, a revolution still needs to come from somewhere, maybe looking at the Commission, maybe even from the authors. Second big problem we identified is the way prohibitions have been framed, defined. Again, without going into very important details, it's even hard for me to criticize those because the devil sits in the details of these definitions. Anybody from outside our field who gets a glimpse of it says, oh, great, EU is going to prohibit a very unethical uses of AI, excellent. But if you read these definitions as a lawyer, you immediately see how easy they are to circumvent, how rigid these definitions are, and also how many intuitively bad, ethically controversial, risky implementations would not be covered by these definitions, starting with predictive policing, which has made it to the draft report in the Parliament, but again in a pretty narrow form. So a lot of improvement needs to be done to the list of prohibited systems. Then there is a whole important area covered by a panel before this panel today, which is obligations of users. As you all know, and it has been mentioned already in the introduction, we are talking now about a regulation focusing on providers, developers, far more than users. But context for AI can be everything. You can have a very well-designed general AI, or not even more specific AI system that has been through all the compliance assessments while being created, but then the specific use affecting human beings may pose controversies. So it's extremely important to fill this gap, to add more obligations on the users. And again, the progress has been made in the parliament with that regard, but still without a key element that has been always a demand from civil society, which is demanding that all users of high-risk systems do a human rights impact assessment. I don't think it's too much to ask in the context of the huge bureaucracy designed for developers. If developers can go through all levels of bureaucracy, why users of high-risk systems should not do this one important checklist, publish it, make it available for independent scrutiny, and be more transparent. Another point is what Omar already signaled at the very beginning, the lack of individuals there, the lack of effective redress, transparency mechanisms for affected individuals. I think I understand the thinking in the Commission, in the European Commission, was that we should rely on the GDPR and other legal acts for this, but unfortunately GDPR is an old legal act by now, and by no means it can give us a flexible enough system for explaining AI-driven decision-making processes, because Article 22 of the GDPR, I mean, for ages we've been discussing here why this is not enough. So let's not go back into that loop. I know as a lawyer I would endorse the idea of having the regulation, nicely packed in the right headings, but we cannot open GDPR. We won't do that anytime soon. The AI Act is the place to fix some of the flaws of the previous regime and really guarantee that affected individuals, not only by manipulative systems covered by this strange, very narrow, again, Article 52, but all affected individuals, at least affected by high-risk systems, but we wish for more, can go somewhere to seek redress, to demand transparency, demand explanation, expect human review. All that needs to be filled. And maybe I stop with these high-level lines and we discuss more in depth.
Great. So, Jean Claudio, what's not to like about this regulation?
Thank you so much for this opportunity. And I think I will build on what was just said. So trying to follow the same structure. About the risk assessment, it's very interesting the fact that, I mean, not just interesting, but demanding for enforcers and people that will need to implement the difficult relationship between the risk assessment in the GDPR. The risk assessment in the AI Act, which is a predetermined risk assessment because you already know the unbearable risks list, and so the prohibited practices, the high-risk list. But even in that case, high-risk AI systems need to do a risk assessment. And then how we combine this with the risk assessment in the Digital Services Act, for example. So this will be something not just in terms of changing the law, changing the proposal, but something for us, for the audience of the data protection, I mean, DPOs and regulators and enforcers. About the list of prohibited practices, yes, I mean, I agree with these points that you raised. In particular, I would like to develop two points. We know that in Article 5, and this list of prohibited practices, we have the reference to dark patterns, we can simplify, leading to physical or psychological harms. So, first of all, we have a problem about the definition of harm. And it might be, this is a long discussion in the legal field and in data protection field, because harm is a bit ambiguous word. We know damage. Civil law people know the notion of damage, quantifiable losses. Harm is voluntarily ambiguous, and ambiguity can be a good point, but if we specify it better, can be a good point. Otherwise, in the ambiguity, we can have many issues. Then, why just physical and psychological harms? Why not, for example, economic harms? Usually, dark patterns produce economic harms. I asked this question in other venues, and the answer was because we already have the Unfair Commercial Practices Directive. Well, yes, we have the Unfair Commercial Practices Directive, but it was a directive written in 2005 where AI was not a buzzword, and where, you know, upon a neoliberal approach of consumers as rational beings and so on, with the particular view on vulnerable consumers. So I don't know if we can be safe with the Unfair Commercial Practices Directive alone. Then also, the second part, I mean, another point of Article 5 refers to exploitation of age and disability, exploitation of vulnerability based on age and disability. So this, yesterday at the opening, we had the opportunity to focus about vulnerability, vulnerable people in the AI Act, and we launched this observatory about the International Observatory on Vulnerable People in the Data Protection field. It's called Vulnera. So the first point to address was this. So is it okay to consider a prohibited practice just the exploitation of vulnerability based on age and disability? When I asked this question, the first answer was age and disability are easy to check because you throw an ID card or a medical certificate, you can prove your vulnerability. But in this regard, the Slovenian presidency made a great step forward because they had also vulnerability based on social and economic conditions, which is totally the opposite of predictability, right? How can you prove that you are in a situation of social and economic vulnerability? But still, it's very interesting also because, so I don't want just to criticize, I want to say that this reference to vulnerabilities are very interesting, even because there's no link, direct link to a demonstrable harm. It's just likely to harm or harm. But then, is it enough to take into account just age, disability, and social and economic conditions? There is another part of the AI Act that addresses vulnerabilities. That is Article 7, where basically these are some requirements that the European Commission can follow to update the high-risk list. So now we are not in the prohibited risk list, in the prohibited practices, we are in the high-risk practices. And Article 7 defines vulnerability in a way, they say, the extent to which potentially harmed or adversely impacted persons are in a vulnerable position in relation to the user of an AI system, in particular due to an imbalance of power, knowledge, economic or social circumstances or age. So just, I mean, one joke about the user definition that Omer was saying, that now the user is we can say data controller. Actually, it goes back, I discovered that in the UK report 1978, the user was the data controller. So basically, we are going back to that model. But just, I mean, apart from the joke, this definition is very interesting, this definition of vulnerability, because it doesn't define vulnerable people, it defines people with vulnerabilities. So this is a new approach. You are not vulnerable, you have a vulnerability, and this is like a contextual notion, layered notion, and so on. Also, the fact that they are not damaged, but potentially damaged. So this is also something positive, of course. And also, they refer to power imbalance. What is power imbalance? I think we could have like 4 hours panel about power imbalance. You know, in the last months I did some, brainstorming about power imbalance in the big tech scenario, because it's also power imbalance being locked in, basically. So every person is vulnerable when we are facing Google or Facebook, and we have Google in the panel, so we can hear about that. But is it realistic that the European Commission will will update the high-risk list following this vulnerability list? Omer was mentioning the top-down approach of the AI Act. Maybe a way to counterbalance this top-down approach was to give the power to update the high-risk list also not to the European Commission, but for example to, I don't know, the EDPB coordinating some data protection authorities list. I don't know, this might be something. Of course, it's difficult to do enforcement in this way, but, the European Commission is driven by, there are commissioners that have a political mandate and particular sensibility. Of course, it's one of the best institutions that can balance different interests. But as you were saying, maybe a bottom-up approach might help. I don't know. And yeah, so just these points, of course, and last point, and then human rights impact assessment, also very interesting point as a proposal of the co-rapporteurs, but how to do it in practice, right? So we have the data protection impact assessment in the GDPR, great as a concept, very difficult to do it in practice, the fundamental rights part, right? We always repeat the same thing, but how do we measure the impact on fundamental rights? Likelihood, okay. Severity, how can we measure severity on fundamental rights impact? We had the panel this morning, I was trying to make the same question, and there are some first steps to solve the issue, but so for now, I think.
Great. So we heard some critique from civil society and academia. I want to hear some from the other side and start with Sylvia from Google, and then maybe Charles can tell us about what he sees from his clients. Sylvia, how clear and feasible are some of the requirements of the AI Act? I know, for example, from reading the comments, a lot of industry players weighed in on Article 10, which requires that training and testing data be complete and free of errors. And some industry players said that's not feasible and, in fact, might be counterproductive when you want to prove that there is bias in the system. So tell us a bit about Google's take on this draft.
Thanks so much. I'm happy to represent Google and kind of wider industry views on this topic. So maybe I will start actually that there is a lot to like in that regulation. That's a kind of, maybe not a critique, but from the industry perspective, the kind of the risk-based approach, the focus on kind of this pyramid of risk when you have actually, certain prohibited practices, certain high-risk scenario, in majority of cases where actually, that regulation doesn't kick in is something important. And I know that the innovation word was mentioned here once, but from those companies that actually develop, deploy, and provide those technologies and see a great potential in it, I think that's quite an important one. Some of the points that from Google perspective, we believe that could benefit from additional clarity have been mentioned. One by Katarzyna, but maybe we can come back to it later. AI value chain is extremely complex. The AI Act has been based on kind of product legislation where you have a physical product, but AI value chain is much more iterative, much more nimble, much more flexible, much more many actors involved. And the kind of from the provider perspective, indeed the majority of the obligations fall on those providers because we are thinking about manufacturer of a product. However, AI is very much different. So that's something I'm happy to come back later, but very much agree with Katarzyna saying that we need to think about use cases, how those technologies that oftentimes have this general purpose solutions that kind of off the shelf that can be used and plethora of different use cases, and those actually define the risk profile. That's something I understand, Omar, you want to come back later. In terms of the feasibility of legal requirements, maybe a thought from my perspective. We roughly kind of agree that the legal requirements for high-risk AI, they really make sense, focusing on data quality, documentation, human oversight, transparency are the important factors to determine, the type of AI that we want to have in Europe. And very many of them are also kind of grounded. If you look at what was before the AI regulation, AI Act, a lot of players in that field, including Google, have developed, their ethical codes of conduct. There was this kind of high-level expert group that developed ethical guidelines. So if I look at Google's AI principles that were developed in 2018, and I compare them with AI Act, very much alignment on the kind of the objectives that we have. We don't want to have AI that would be biased. We don't want to have AI that would be opaque. I think there is a kind of a huge alignment on that, but of course the devil is in details, and as Giancarlo was saying, sometimes the ambiguity is helpful, sometimes not. For industry, ambiguity is oftentimes sort of complex and makes people nervous in terms of what actually is required when you want to comply. And indeed, Omar, you mentioned one of the example. I think that's the kind of the one that has been circulating in Brussels as widely understood. And I think the Commission even said that that might have been, a bit of a not perfect writing, but indeed looking at Article 10 and ensuring that training data is free of errors, 100% relevant and representative. That's something that is unfeasible from kind of legal and technological perspective. Another sort of example I could use is, for instance, requirements to have kind of a full understanding of the systems. I mean, many AI systems, whether they are kind of complex models with billions of parameters or even simple hand-coded models, fully understanding them by all different actors, it's probably effectively impossible. So kind of aiming at standards that allow to adequately understand them and looking at specific actors. If you think about AI used in the healthcare system, there is a different level of understanding needed for a doctor, different for a nurse, different for a patient. So I think adapting those requirements with the use case and a specific actor is something that will be important. And maybe one other thought that I wanted to mention in terms of support for innovation. That's not in the Commission draft, that's not kind of fully articulated to that extent, but at least from what's important from Google perspective is the clarity around what happens with AI research, right? Like we are talking in the AI Act about putting on the market or putting into service, but sometimes the kind of line between where research stops and when it's put on the market is sometimes being blurred. But if you look at AI, in particular the open source models that many of the great solutions are being built, oftentimes it kind of also stays in the research perspective. So from that perspective, a plea for us to make sure that research and development in those technologies, it's not being stifled with the AI Act. And I understand we will come back to responsibilities a bit later in the discussion. So I will save that one for later.
Great. Thank you, Sylvia. Charles, what are you seeing and hearing?
Yeah, thanks, thanks all. So first, and of course, providing the business perspective is sometimes challenging, but I think everyone should realize that, and you mentioned it in your introduction, that we are dealing with something that is complex on its own, because it's mixing safety and human rights, basically. And I think, hopefully, everyone may agree or can agree that if you have an AI system with making sure that a car drives autonomously, that one should probably go right. And if it messes up, it comes with liabilities. And everyone kind of probably agrees that we need to have good data and all of the other, let's say, safety pieces of that approach. What makes it much more complicated is indeed when you go to things like discrimination, state surveillance. I represent business, but I certainly don't want to live in a society that looks like China. And so I have no issue whatsoever that the political position should be or could be no facial recognition whatsoever by public authorities and law enforcement unless in a very limited circumstances. I'm almost fine with the approach. It's complicated to then drive from that kind of general understanding, go much more granularly on the AI uses, which is indeed what the regulation is trying to achieve. So really trying to tackle wrong or bad uses of the technology. To do that, I think we should be ambitious in the list of prohibited uses, because that's really where you probably put EU values where they should. So if you are strong enough, and of course we can diverge on what should be there, but I think like at least conceptually, we should be strong and in putting in that list all of what is really problematic for fundamental rights perspective. And when we have done that, we can almost get like purely technical on the AI Act, because what this regulation should be doing is indeed conformity assessment, users documentation, and really making sure that all of that is tackled in a way to make sure that you have safe product on the market. Then I, of course, understand why civil society rather prefers to have this opportunity to tackle all of what is going wrong on other piece of EU legislation, but still, if AI is an horizontal regulation, which it is, I think we should have it working like that, so as an horizontal regulation, meaning you have an umbrella and then little piece of pillars, and in those pillars you will have consumer protection, you will have anti-discrimination law, you will have public safety, liability, etc., etc. And I'm fully aware that it's much more complicated in all of those regulations or directives that are undergoing change as we speak. It's probably much more complicated to be effective in all of those and get to the outcome we want. But I really think that for legal certainty, it works much better than trying to put in something that is not really made for this, a lot of different things. And I'll just give 2 examples. Collective redress for AI use breaches, let's put it that way. We have an annex in the Collective Redress Directive. We could just or make sure that we have the AI Act in that list of things that can be subject to collective redress. We don't need to have collective redress mentioned in the AI Act to make it work. That's one example. Where I have some more fundamental issue, and Jean-Claude, you alluded to it, is indeed it's complicated to see what will human rights impact assessment, whatever is the name, what it will achieve as a result, and what will be the benchmark, because you will be benchmarking a use against what? Against anti-discrimination, against freedom of speech, against, and it will be very complicated to find even a methodology probably to achieve that kind of results. I'm not saying it's impossible, but I think it will be very challenging for business to proactively and consistently applying those type of tests. So I rather have a regulation that really is pretty clear on the prohibited use, and that is as clear as it could on the rules that are applicable to the AI system that are in scope, basically.
Great, but that's really great, and I feel obliged to let Anna respond to all this. I saw she was taking meticulous notes and in fact editing the text of the regulation even as we speak here. I'll just say, Charles, that I find it really interesting what you're saying about sort of the challenge of combining product safety and human rights in a single legal instrument. And in fact, as you're talking, I'm thinking maybe the prohibited use is where the human rights kick in, where it really impacts human rights. That's the category. And then if it doesn't, it becomes like a product safety, kind of product liability, kind of more technocratic thing, as I said earlier. Sylvia also had an interesting comment, which I'd like to sort of discuss here, which is that it's impossible to fully understand the AI systems in some contexts. So that's obviously, something that I think is contentious and merits discussion. But before we do all that, Anna, there was, people raised a lot of issues here. I'm sure you hear a lot more, from the submissions and the Parliament and Council. How will the Commission consolidate all this?
So first of all, I would like to say that I'm very happy to hear all those comments, and I think that we need to have a very good debate and very open debate about all those issues. And it's extremely good to see that there are so many stakeholders very actively engaging with this legislative process. And I believe that it's only by voicing those concerns, praises, as I heard also for the IE regulation, will actually lead to the best possible outcome. So that's the first thing. So also thank you to my co-panelists already for putting their thoughts out there. And well, maybe I would also like to come back to this comment that was repeated several times, meaning that, that we are dealing with a horizontal regulation, the regulation that is about the product safety. There's basically, in its very nature, the market regulation. But I would also like to point out that it is a regulation that also very consciously, and I think it is in a certain way a paradigm shift, very consciously refers to the fundamental rights protection. It is a regulation that very explicitly indicates that safety, but also fundamental rights protection is a key objective of the whole act. So, and I think it's a novelty. I think that should receive the good attention. There are so many comments, there is difficult to react to everything, so maybe I will focus on something that I know best, which is this relationship with data protection acquis, and whether or not one could rely on the instruments of the data protection in the context of how we look at the IE. And I think here there are a few things that I think we should also notice. The first is that the IE Act applies to all variety of the applications. Not all of them would actually process personal data. So we have a layer of protection where the processing of personal data is not taking place, then it would be difficult to rely on the mechanism of the data protection acquis. But having said so, another thing which was also mentioned is that the Data Protection Act is not an act which exhaustively regulates the whole sector. It's not the act that puts all the rules relating to IE in one bit. Quite to the contrary, any other requirements, there are many other requirements that equally applies, and data protection is one of them. So we have a situation that when the processing of personal data is going on, and fair enough, that would rather be a frequent occurrence, we have an application of both frameworks. So the both frameworks apply simultaneously and concurrently. And it also brings me to another thing, which is, as it was already mentioned, the IE Act names the IE applications which are prohibited. It also indicates the IE applications which are high risks. And for the high risks, there are a number of conditions that must be fulfilled before that application is put on the market. It does not mean that if the application is the high-risk application, that there is any presumption of its lawfulness of legality on the other frameworks. So it has to be stressed that that application has to fully comply with other frameworks, and data protection is one of those frameworks. So the high-risk application, even fulfilling all the procedures and conditions in the IE Act, still has to make sure that the data controller has to make sure that there is appropriate legal basis for processing, that there is proportionality and necessity, that data subjects' rights are upheld, and all other requirements that comes from the GDPR and from the Law Enforcement Directive. So these are the general comments, and there are also a few things that maybe I would just take opportunity to point out in terms of more meticulous intersections between the two frameworks. And that intersection, so as I said, the data protection framework fully applies, and the IE Act is building up on it, it's supplementing it. And we see it in particular in two cases. So we see it in the cases of the bias. So we have a specific provisions on the bias detection, monitoring, and correction. And this is also the provision which recognizes taking care of the bias as the significant interest. And because it is the significant interest, public interest, it is IE Act that provides directly a legal basis for processing for those purposes to address the bias. The second example of that we have in the sandboxes. So we have the IE Act, which says that you can create the sandbox in order to test, validate, develop the IE Act. The purpose of the sandbox is to create the favorable environment for the development of the IE, but also one of the objectives of the sandbox is to make sure that the product is finally fully compliant with requirements of the directive, and that would also involve requirements to fully comply with the data protection. As a measure to facilitate the IE Act provides, again, directly a legal basis for processing of the data that has been previously lawfully collected, and that would be if the IE application in question serves, again, the important public interests such as public safety, public health, the protection of the environment. Yes, and I think right now is a good moment also to go into the topic of the law enforcement and how that is shaped under the IE Act and, well, the data protection acquis. And here we have a situation that for law enforcement objectives, so IE for law enforcement can also benefit from the sandbox. There, however, there is a requirement for the law, for the member states' legislations to provide the legal basis, and it's in the recognition of a particular sensitivity of the data that we are talking about. So because basically we're talking about operational data being used in the sandbox. Another, of course, intersection is the remote biometric identification systems. So here we have a situation where the IE Act is actually providing a lex specialis provision comparing with the law enforcement directive, actually. So under the law enforcement directive, the sensitive data, that includes biometric, can be processed only when strictly necessary and under certain conditions. And basically, in the context of the law enforcement, it means that such processing needs to be authorized by law, consider data which are manifestly made public or concerns the processing for the vital interests of the data subject. So as we also know, and it has been discussed, that the IE Act is basically taking a position of prohibiting remote biometric identification in public spaces for the law enforcement purposes, with limited exceptions. And when we go to exceptions, we see that all those exceptions are actually framed as a high-risk systems, subject to specific obligations, and subject also to specific conditions regarding the proportionality, necessity, limitation in time, space, regarding the personal scope as well. And there is another limitation. So even if we are talking about the exception, there has to be a law that frames that processing. So the remote biometric identification under IE Act has to be framed by law, and that law has to also fully comply with the requirements of the law enforcement directive, including requirements that are put it for the quality of that law in lead. And here I think it's very important also to mention that the recent guidance of EDPB on the facial recognition, adopted very recently, I think was a week ago, where EDPB actually indicates and stresses that requirement that, you know, you have to have a quality legislation, and you have to, and it's not enough just simply to repeat and just to give a very broad authorization for processing. Mindful of the time, I will actually stop here, maybe with one final comment that I just mentioned the most important interactions between the systems. I think what is also very interesting to see is that we have other number of provisions, another number of obligations which are put on the processors and to some extent the providers and to some extent the users. which I think are actually operationalizing or embodying the mechanisms which are already provided by data protection legislations, which is the risks assessment, that is security requirements, that is the quality requirements, and so on and so forth. They are put forward, but operationalized a bit more specific. So I will stop here.
Great. Thank you for that response from the Commission. One of the, I think, unexpected changes that CPDP has undergone from the pre-pandemic January version to this version, the end of May, is that it's extremely hot here. And I heard that next year there will be an AI that will sort of calibrate the temperature in the room to the preferences of the audience, but there isn't yet. So all this is to say thank you for sitting here in stifling heat and humidity. And I really want to allow all of you to ask questions and interact. So I see there's a microphone up there, and maybe there's a roving one, I don't know. But, or you can speak up. Who has questions for the panels? Yes, first row. Maybe I can do this. If you could just introduce yourself.
Yes, my name is Oscar Stein. I'm an assistant professor at the University of Groningen in the Netherlands. I just have a question. Maybe it's quite technical, but it was triggered by the talk about the sandboxes and especially what the law enforcement could use. So are there any considerations or thoughts relating to the use of synthetic data in the training of algorithmic systems which are, or AI systems which are in the proposal, or could they play a role? Synthetic data being data that is generated according to parameters set by data scientists or others, and then modeled after people, but not personal data, strictly speaking.
Yeah, but Anna, synthetic data.
Yes. Yes, of course. So the sandbox, provisions of the sandbox also require appropriate safeguards, and one of those safeguards is also the assessment whether that processing, whether that whatever needs to happen in the sandbox can actually be, first of all, done by data which is anonymous, pseudonymous, that would include synthetic data.
Although, of course, the Act applies to data irrespective of identifiability, right? As you just illustrated, GDPR is an additional layer. Yes, question up there.
Yeah. Hi, my name is David. I'm a policy advisor for the Dutch Ministry of Economic Affairs. And we've been talking a lot about better biometrical identification, but I think another big issue are deepfakes. As the conflict in Ukraine has also shown, there was this imitation of Zelensky, who apparently had a Russian accent, so it was not that effective in the end. But currently, the countermeasures that are put in place in the AI Act are just related to transparency requirements. So you have to be aware that you're talking to a deepfake, but for example, it's not listed under Annex 3, which is, of course, the high-risk standalone AI. So my question would be, do you think that only the requirements of transparency are enough to counter the, I would say, ever-growing danger from deepfakes?
And if I can just jump on that, you mentioned Annex 3, the high risk, but should deepfakes actually be a prohibited use, maybe? Maybe start with you, Jean?
Just to say, I agree with you, in particular, not just that part of Article 52, but also the emotion recognition part that at the beginning was considered not high risk, not even high risk. And I think that the amendments of the Parliament are working in this direction to, upgrade the level of risk of these tools.
Anyone else on deepfakes? Charles, you have thoughts about it?
So very, very, very briefly. So of course, we need to make sure that we don't have AI to generate deepfake. We also see in other instruments that are currently close to adoption, that you have measures against deepfake or similar type of bad uses, let's say. Here again, so I think we should not create new tools for things that are already regulated elsewhere, but on the principle, of course, I fully agree. Yeah.
Katarzyna?
No, just to say this is an excellent example of something we could have even had considered in the prohibitions part if it was made more flexible and future-proof as civil society has been asking for. We don't know how that area of innovation will play out. Now we can almost classify, like 5 years ago, you would almost classify it as entertainment, like porn and tabloids, and today we do say it differently, right? We really don't know how it will all develop, so it's just a strong +1 to increasing flexibility and more future-proof list of prohibited uses of AI for me.
We had, I think, one on this side. Yeah.
Thanks.
Michael.
Yeah, Michael Veal from UCL. I wanted to ask about the standardization process. So we've talked about a paradigm shift in human rights here, and also potentially high-risk systems being more of a technical standards issue. But we also see the kind of rights that are being referred to, things like good administration, right to justice, free movement and borders, all in the high-risk areas. And the Commission in its recent standardization strategy and paper accompanying it really lambasts the inclusion of civil society in standardization processes. It's struggled for many years, and its solution is to move the representation to national standards bodies and effectively to move civil society engagement there. But civil society doesn't engage in these bodies. These bodies aren't used to dealing with these rights whatsoever, and the stakeholders that are familiar with these rights aren't actually familiar with the standards setting system. So what does the Commission and similar actors, what are they going to do to ensure that when these technical standards are being hashed out, there's actually inclusion, because these are rules that will really matter?
So I think actually there is a big role also again for civil society and for activism to actually raise the issue and engage with the standardizations bodies. They are not necessarily, well, I mean, so those bodies, they are not necessarily controlled or by the Commission. So it's not that the Commission can point the fingers and say that from now on you operate this way. I think that actually raising this issue and putting, as I think it's a nice expression of putting the fundamental rights on the forefront of the design and standardization is already a good sign also for those bodies to refocus their attention and hopefully also take this into account in the future.
You want to?
Yeah, very rapidly. I would like to repeat something that Michael Veal has been saying in the past about not just standardization, but harmonization. The high-risk list applies, the accountability duties applies to high-risk AI, and the higher harmonization level might block member states to protect more. And this is an issue that we should consider. And about participation, I think this is a key point. Yeah, stakeholder participation in the standardization. I know that there are amendments now from the co-rapporteur about this, but why don't we focus a bit about participatory design in AI? Now it's a very forbidden part of Article, I think, 55 about code of conduct, but we said that there is no individual rights. We said that consent is a problem. We said that there are vulnerable people. So why don't we push for participation of vulnerable stakeholders in the design of AI? I know it's difficult, but if now is the AI Act, if now we miss the opportunity to give more importance to that part and we just leave to, oh, voluntary code of conduct, if you want, you can ask people to be involved in the loop. Isn't it better to have, a stronger position on participation?
So there's language on access to source code and to training data, and that actually attracted a lot of criticism from industry voices in the call. But do you want to talk about it, Sylvia, about access to source code?
Happy to. I think you kind of referred to Article 63, kind of access to source code for market surveillance purposes. I mean, you would not be surprised that from the industry perspective, that's always a sort of a red flag, mostly because, in the current wording from the Commission, we didn't see enough kind of intellectual property and trade secret protections, and also because of the kind of proportionality in the sense that if you want to kind of check whether companies are kind of including the right quality of data, that there is human oversight, that there is transparency for those high-risk AI applications, I think you would not achieve that necessarily through just kind of having access to source code, but kind of more meaningful ways of checking against those requirements would probably be much more effective in achieving the same sort of objectives. So, as I say, first of all, more protections on IP and trade secrets, and then kind of adjusting what's actually kind of is going to meet the effectiveness of the objective in mind.
So thank you for patiently waiting.
Yes, thank you. I'd like to, my name is Elizabeth. 5 minutes left. Sure. My name is Elizabeth Steindl from the University of Vienna. My question would follow up on the one that we had before on Article 52. So one good news is that emotion recognition might be upgraded to a high-risk category, which is, of course, welcome to anyone working in that field. The question that remains, however, is if the definition of emotion recognition system will remain as it is, meaning relying exclusively on biometric data, which leaves out any emotion AI that does not rely on biometric data, such as, for example, natural language processing, which is not considered biometric, or depending on the definition of biometric, whether you consider soft biometrics part of that definition or not. And the second part of the question would be, it does, of course, help the situation with emotion recognition systems, but as for Article 52, if transparency obligations for medium risk category AI system is actually the best we can do in terms of regulations, because it triggers, the only thing it triggers is a transparency obligation. So if the data subject, the end user and the user, the deployer of the system, are identical, it's useless because the AI system would tell you what you know already by using it. If those two fall apart, if the data subject or the end user and the user of the system are different ones, the only option that you're left with as a user is not to use the system at all. There are no rights going with it or accompanying these transparency obligations. There are no other obligations for the deployer, for the manufacturer, for anyone. So this part would be, is that really the best that we can do for medium risk category systems? Thank you.
Charles, you want to take a crack at it?
Yeah, and really as a response to you and as a 1 minute conclusion, so I really think that it's important that really context should provide the remedy. So if you have providers that are providing bad AI systems, they will be out of the market, sued, and they will not last for very long. So that, I think, is where probably police will be done by itself. Thank you.
I want to maybe close with a quick question to you, Katarzyna, and maybe others want to weigh in. Commissioner Reinders said in his opening statement that he foresees the AI Act becoming a global standard, much like I think we've seen GDPR in the data protection context. Seeing as the United States, for example, has legislation and even a lot of jurisprudence already on facial recognition, for example, and biometric data, and laws about automated decision-making. China has a lot of regulation about algorithmic recommendation systems and smart cars and other kind of aspects of AI. Do you see the AI Act becoming this global standard that Commissioner Reinders hope it will be?
In that shape, well, maybe a very comfortable framework for industry especially deploying AI, yes, because it doesn't really harm them. So my current take on the AI Act, not improved yet by the Parliament, I wouldn't be optimistic about the global impact of that legislation because it's pretty rigid, very narrowly focused, and as we said, it has a long list of flaws. But if I may, on the 2 points that came in the questions and here in the panel, One is this idea that if we just get rid of the most harmful uses of the AI in prohibitions, the less can be bureaucratic and pretty low obligations on industry. It just takes one look at Annex 3 with high-risk systems to see a range of extremely problematic, potentially harmful for human beings uses of AI, and not even starting to talk about consumer uses mentioned by some of the speakers in the audience, like mental care, health-related apps, or even recommender systems on global platforms. Really, we have so much human-relevant AI around, we cannot have that regulation go with all the loopholes and just limit it to prohibitions. And the second thought is the human rights impact assessment. Yes, nobody here is asking for a checklist, which will be just, do and forget. And this is my last suggestion for today, is to take a look at Annex 4, full of extremely useful ideas already from the Commission of how transparency and meaningful transparency and technical documentation can be designed to reveal the impact and discuss potential impact without going into measuring severity or likelihood or any other problematic high-level questions. So if we have some of the Annex 4 provisions for users of AI, we already have a lot.
Thank you very much, Katarzyna, and thank you to all our speakers here and on video. Thank you, Sylvia, and thank you for joining us for this session.